At exactly 9:30 a.m., Col Dr Kiiza Besigye and co-accused arrived at the General Court Martial amidst heavy deployment. Brigadier Freeman Mugabe, the chairman of the court, started the ruling against what the defense lawyers were objecting, saying that the court has no jurisdiction to try them in General Court Martial and that the arrests were unlawful. In response, the court's decision was based on the grounds that the accused went through lawful arrests as per the Memorandum of Understanding (MOU) between the governments of Uganda and Kenya.
In reply, Counsel Raphael Mugisha for the state submitted that jurisdiction is a creature of the statute and therefore Section 208 of the UPDF Act gives jurisdiction to this court to try the accused person. Our counsel further submitted that the words defense forces are defined in the UPDF Act to mean Uganda People's Defense Forces, and therefore the submissions of counsel to the accused are misconceived and should be ignored by this court.
The defense lawyers, however, urged that the trial was unfair and requested the court to refer the case to the Constitutional Court.
And agencies of the state shall accord to the courts such assistance as may be required to ensure the effectiveness of the courts. Effectiveness of the courts includes its judgments.
Each and every of the above, rather not of the above constitution, each and every one of the above constitute what the right to a fair hearing means. It was never intended that this would be an exhaustive definition of the right to fair hearing.
Raised earlier, questions of discrimination, questions of a lawyer who is part of the team being arrested and detained and therefore not available, questions of fair process.
The state prosecutor countered that the issue of impartiality was baseless, citing Articles 142 and 194, which state that the Commander-in-Chief appoints all judicial officers.
You cannot get a fair trial before this one. The same person who appoints these justices and judges is the same person when you look at the section 194 of the UPDF Act.
The prosecutor also referred to Section 4 of the Penal Code Act, which states that anyone committing an offense within or outside Uganda shall be dealt with as if they were in the country.
I want to implore you to look at Section 4 of the Penal Code. The offense can be committed. The offenses committed also almost the same wording as Section 208 of the UPDF Act, where these officers are asking, where do we get jurisdiction to try an offense which was committed in Kenya? So it is Iran. It's not what is special about this. It's not news.
The court ultimately adjourned until February 3, 2025, after reading out the charges against Col Dr Kiiza Besigye, Hajji Obeid, and Captain Denise, which include 5 counts of unlawful possession of firearms, holding meetings, and treachery. All the accused denied the charges.
320 particulars of offense. That Dr. Kiiza Besigye and Hajji Obeid Lutale on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, were found in unlawful possession of a pistol model HB 1015 1953, which is ordinary monopoly of the defense forces. So, Col Dr Kiiza Besigye as before. Plea of not guilty and Hajji Hajji Obeid Lutale, have you heard the story the judge read to you in count 5?
Yes, I decline.
A plea of not guilty entered.
Defense lawyers Martha Karua and Lukwago were not in agreement with the court's decisions. These assured the public that they will find ways of executing the case.
Say I'm declining to take a plea. And it's up to them to record whatever plea they want, whether it's a plea of guilty or not. But in law, once one declines to take a plea, they are obliged to do to record a plea of not guilty.
But they should also record that our clients refused to take plea. Therefore, the court has entered a plea of not guilty.
Insist they are not subject to martial law. Yes. It's the reason they have declined to take a plea. We have persistently put across that argument. We have invoked all the relevant laws to back up that argument that our clients are not subject to military law. They are not subject to martial law, and therefore this court has no jurisdiction to try them here.
Who is giving the orders? Although the regulations are very clear that he gives the advice, and the court can refuse to take his advice for good reason, which must be recorded. That to us means that we, the defense, can persuade the court not to take the advice of the judge advocate when it is misleading. But it's now no longer possible in this court because it's under total control.
Naguja Serena, NSTV.